Hello, good afternoon, everybody, and welcome. I'm really excited today to be having a conversation about privacy litigation. And I have with me Katherine Heaton at Beasley Insurance and also Melissa Siebert at Cozen O'Connor, outside counsel, who has done a lot of work on privacy litigation. Briefly to introduce this topic, I think for a very long time we've had data breach litigation. We've had a lot of cases involving data breaches, and just a very, very long story to that litigation. Where I think the short story is, courts initially were very skeptical to plaintiffs' claims. Most cases got dismissed. But over time, that's changed. And I think with data breaches, more courts are finding standing than ever before, even though the Supreme Court has issued several cases that have generally tried to pour cold water on the standing. It seems that the litigation on data breach has become more robust and plaintiff friendly. Privacy is interesting because for a very long time, privacy litigation was rather sleepy compared to the data breach litigation. But in recent years, we've really seen a massive pickup in the litigation on privacy. We've seen the different litigation theories emerge. So in particular, the California Invasion of Privacy Act and other state wiretapping laws being used in a variety of ways to sue for various forms of online tracking and other technologies. We've seen also the use of the Video Privacy Protection Act, or VIPA. So we'll be talking a lot about that law. For a while, there is a law that has been used for litigation for longer, and a more recent law, the 2008 law in Illinois, the Illinois Biometric Information Privacy Act, BIPA, and also the Driver's Privacy Protection Act, DIPA. We'll dive into these laws and get into all of this. But first, I'd just like to start off with to get your thoughts on some general trends with the litigation. I'm going to look at the big picture first before we go into any specific law. What are you noting about the general trends? Do you agree with me that the privacy litigation is relatively a new development? And where do you think this is going? Why do you think this is happening? How would you describe the landscape if we look at the privacy side versus data security side, the privacy side of litigation?
Yeah, from an insurance perspective, we saw just a huge surge, I would say, starting in 2022. So prior to 2022, we had these claims. They would come in, but it was smaller. Sometimes we'd get little pockets. I think, for example, in 2020 and 2021, there was just a little flood of claims in Florida under the Florida wiretapping statute. They all resolved within just a couple of months and went away. But in 2022, that's when the real surge of litigation began. We started to see a lot more VIPA claims. We started to see all of those wiretapping claims. I think that what happened is that, as you said, this hadn't been sleepy. The focus had really been on breach. And some of the non-breach claims started to get traction. So in early 2022, for example, you had that Mass Gen partner settlement of $18 million. That was a hospital that was using pixels on its website. And I think that was one of the first turning points when plaintiffs' counsel started to realize how broad this was, and the fact that just about every hospital is using this on their website. And then beyond hospitals, just about every website uses some sort of pixels. And you can see the application of wiretapping statutes to these claims. We just saw just a flood of litigation, a flood of demand letters. I think there's more demands out there than class actions filed even, and that just continues to roll in.
Agreed. I mean, I think it's just been an amazing surge. I mean, in Illinois, Chicago in particular, where I'm based, the BIPA claims, you started to really see those biometric privacy claims just trickling in 2016, 2017, and then in 2018, just this massive surge where in that year alone, more than 2 new BIPA class actions were filed like every day when you average them over time. And you're seeing that now in the SIPA landscape, just an amazing number of cases. And Dan, I think what we have noted is not just the surge in litigation, but it's filing every possible type of claim under a statute and just exhausting the technologies to which and the statutory provisions to which it might apply, and just seeing what sticks, which of those theories pan out. And you've certainly seen that in SIPA as folks have moved up and down the statute and within the wiretapping provisions in particular to really connect whole new types of technology to purported wiretapping, eavesdropping claims.
Yeah, I think that this is a product, if I had to sort of put a theory on like why are we seeing this now, I think it's a product of the fact that the new privacy laws, and we have 20 consumer privacy laws in the states, they don't have private rights of action. And I think people have been clamoring for a very long time, hey, we really want protection here. There are these concerns. They've been bubbling up. We don't have action at the federal level. The states have stepped in, but I think those laws are rather weak, in my opinion. And so, if you don't have the right tools to use, you grab whatever tools are out there. And so we see grabbing tools that, from older laws that really were not designed for the technologies of today. These are wiretapping laws that were passed, most of them, I think, in the 60s and 70s, now being used in these very new ways that were not really contemplated when the laws were passed. And even old laws, not wiretapping laws, like the Video Privacy Protection Act. That's a law from 1988. So these are old laws. Legislatures are actually pretty bad about keeping laws up to date, which is, I think, a very big problem in privacy and technology. Is you don't keep your laws up to date, problems like this arise, and if you don't give the right tools to enforce privacy or address a problem, then that's what you're going to have. Old tools, because they're not updated, applied to situations in a rather, maybe not the ideal way that we would want from a policy standpoint. I like to think as a law professor, we want a good, coherent, thoughtful system that has the right balances and the tools fit the situation. I'm not sure that's where we are today, but I think the reason why we're not is because of these legislative failures, these policy failures to really address this long-standing problem, and that the new statutes are just not really, I think, cutting it on a lot of these issues. I'm wondering, maybe we should start looking at some of the specific laws. And I think one of the most contentious areas, one of the hottest areas, the biggest concerns for companies has been the rise of the wiretapping laws and those theories. I'm curious if you could just explain a little bit about, especially the California Invasion of Privacy Act, the SIPA, that law and other state laws. What's going on there? What are the theories that are being used? What are the technologies they're being used against? And what's actually going on in the courts when it comes to those laws?
We're seeing a couple varieties of these. I'll say where it started has been with pixels. And I think that pixel theory is pixels are just little snippets of code that sit on a website. If you have, let's say, for example, one of the most common ones we see in these lawsuits was the metapixel. So if you've got the metapixel on your website and somebody's a meta user, they've got the meta cookie on their browser and they come onto your website, your metapixel will talk to the meta cookie, send information back to Meta. And the claim under wiretapping statutes is that in doing so, there is an interception of a communication. So when you're going on the website, you're doing something there, that's a communication. And then that interception of a communication is it's being shared with some third party that didn't give consent. So most of these complaints are being filed under statutes where you have to have two-party consent. So wiretapping can be like both people would have to consent to the wiretap. So the theory behind this on a two-party consent state like SIPA is that the person who's going onto the website didn't give consent for that information to be shared with Meta, and so they've been wiretapped. And then there's statutory damages that would attach to that. And so that's the theory. There's also wiretapping claims that where only one party has to consent. So for example, the Federal Wiretap Act would only require one party consent. So the theory there is to get around the one party consent, they would have to show some sort of fraud tort exception. And so to make a federal wiretap claim, you'd have to say, well, they're doing something that's fraudulent or tortious. In the hospital context, for example, we've seen plaintiffs' counsel, their theory has been that the hospital is violating HIPAA by doing this. And so that's a like fraud, tortious, criminal type of conduct that's taking place around this. And that's been enough for them to get through about half of the motions to dismiss that have ruled on the Federal Wiretap Act claim. So that's the wiretap theory for pixels. Then there's been a whole other set of stuff. I think we're seeing wiretap coming out of like chatbots. So those are those little like pop-ups that come on that say, do you want to talk to me about your product? Can I help you find something on this website? Those conversations get recorded. And then oftentimes those are mined for marketing or other data. So there's this allegation that that's an interception of a communication violation of the wiretap statute. There's other technologies like session replay, things like that. Melissa, is there anything that I missed on that?
No, I think what you're seeing is the increasing use of pixels. And then there's a lot of noise in California right now, a lot of allegations about TikTok. And as you know, that's a hot topic in the press right now. And so the allegations are that you're using a TikTok beacon or pixel for the same purpose. It's targeted marketing. That's what pixels are generally used for. It's targeted marketing and improving experience on a website so that you visit the website more often and buy things from it more often. But, this pairing up of TikTok is used to spy, to surveil by the Chinese government. That's a very common allegation in these California invasion of privacy lawsuits. So what you're getting is this idea that, there are entities that are spying on you or getting access to your data, as Katherine just referenced, that are, you don't know that they're doing that. So you don't know that the hospital has a pixel on certain pages of the website. And you're not aware that information about you is being gathered in a chat and potentially being sold to third parties for marketing purposes. And I think it's been a wake-up call for many of us, just how much tracking is going on.
Mm-hmm. And sometimes the data that's being tracked is very innocuous, right? So for example, I like to use this for shopping, right? There's a couch I like, I'll go and look at it. Sometimes I might put it in my cart so that they know I'm liking this. I then leave, I come back and I'll say within a few days, I probably got a coupon for that website, or the Facebook might show me other couches that are similar that I might be interested in. So there are, I think, benefits to this. And I think some stuff that like, I don't care if people know what kind of couches I'm looking at. But then there are allegations that some of the information is really sensitive. And so I think part of why we saw a huge surge in the hospital context in particular is that the allegations there are that health, like very sensitive health data is being shared. I can say, having looked at a lot of insureds, that is predominantly not true. Almost everything that's being shared, like most often, it is very innocuous. It's things like, somebody from this geolocation visited website generally. It's not actual health information. It's very, very minimal. A lot of what healthcare does, they'll use things like Google Analytics just to track volume of website usage. It's not sharing sensitive anything, but the allegation is that it's sensitive. And I think what underlying this surge is this worry that what if really sensitive, and healthcare can be extremely sensitive. What if this really sensitive data is being shared and somebody's actually looking at this data for something other than marketing to me? What if they're doing something, what if I get in trouble for this data? For example, we now have some laws in states that are relate to reproductive healthcare rights, for example, right? And if you're in one of those states and you're on a hospital's website and you're looking up care in that area, I think there could be a serious fear that could come back in a criminal way to you, or that could harm you in some way. So I think it's that concern underlying it, but the vast majority of it is not that. And it's still being applied to, even things like my shopping preferences, the couches, stuff like that.
when you look at some of these claims, Dan, too, like it's a basic kind of misrepresentation of the technology, how it works, what information it shares. It's not as sophisticated as, the spyware that's the common allegation that you're seeing, and nor is it being used for that purpose. A great example of those trap and trace claims, for those of you that are familiar with California SIPA litigation, and that's akin to in the movies when they put a bug on your phone lines, and they would then sit in the van and figure out where the calls were coming from into the criminal's house, and try to track where the kidnap victim was. All very dramatic, right? What these allegations are at their heart in these kinds of lawsuits is that when you go to a website, your IP address is gathered. That's a basic operational function of how a website works. That is not a trap and trace kind of claim. It's not what I described. And I think that's where the disconnect is. You are right. The laws have not caught up with the technology, but this is a basic challenge as to how the internet works. One of our colleagues says, is the internet now illegal? If you can't take an IP address in, which is how websites communicate with each other, with how you communicate with a website, without violating a provision of a penal statute, a penal code, things have gotten a little out of hand.
Yeah, well, I think shut the internet down. That's the answer. But yeah, I think one of the problems here is that we really have a wide array of different practices. Everything from just, okay, here's just a basic cookie to, just sort of basic site analytics and the basic kind of tracking a site does, to something that can be very invasive or granular, such as, tracking like pretty much like every single thing that people do on the website, kind of like session replay style tracking. So we see, and then we have a lot of different uses, uses that are, okay, it's just, a first party ad versus, okay, now we're going to transfer the data, have third party ads to ads that follow you all around the internet. So if I'm always afraid, like if I look at this, if I click at this, if I hover over this for a little too long, now I'm going to see like thousands of it in my feeds everywhere, and I can't escape it. So it's scary. It's like, oh my gosh, is it worth it? Is it worth? I'm kind of interested in it, but like, do I want it like multiplied by 1,000 and shouted at me from like everywhere I go? So there's a lot of different practices, and I think each one, has different considerations and concerns. Reproductive health care, very concerning. A cookie, most people, doesn't really matter. Different things like that. So I think that's part of the problem, is that, we have like this one tool, but we have, dozens of different practices that, some are fine and some are, so, and some might be, more concerning, but we have very crude set of tools to deal with them.
What's hard though for the company is that there are also no guidelines as to what you have to ask for, right? There isn't a statute that says that if you're going to use a pixel, you need to disclose it in this way, or you need to get affirmative consent, or you need to do opt-out. But there's just no regulations. It would be so helpful. And I think we got close to having that federal legislation. I was very excitedly watching APRA and hoping we'd get something like that, because APRA would have specified that if it's sensitive data, you have to have an extra level of disclosure consent notices. If it's non-sensitive and it's just being used for advertising and it's not sensitive, you just have to have notice so that people know that you're doing it, but it's not as robust. I think it'd be really helpful if we could get some standardized rules about what is enough for people, right? Like, because I agree with you, when it's sensitive data, I think people should know what's being tracked. And there's some stuff, frankly, that should just never be tracked and never sold, right? I think that like we can all agree that your communications with your doctor about your reproductive health care should not be going to a third-party advertising company. That's just too icky. And I don't think you'd want to even have a consent procedure around that, right? You just shouldn't do that. But there's a difference between that and like most of the hospitals. I would say the most predominant ads we were seeing is they just wanted to get out the word about COVID vaccines. And so that was the most common use for the Metapixel by hospitals, is just trying to get people to get the COVID vaccine. And so it's was not intended to be nefarious. I think there's ways to use it so that it's not, but it would be so helpful if we had actual like regulations seeing what you needed from this perspective.
Yeah, and it's tough. I mean, companies, as you've seen, we all go on a website these days and there's set your cookie preferences. Remember, there are things we can do to protect ourselves, right? Especially on cookies and pixels. It's the norm now that to get on a website, you have to click through quite a few boxes if you want to customize the information that's shared about you, and quite lengthy disclosures about what that information is. But here's the thing. We as a society like to do things quickly. We get frustrated when we have to read through long lists of things. And so we do what we did when we first signed up for Meta or first got, a smartphone. We scroll through quickly, where we say, I agree, or we set the quickest thing we can, and we are on our way. And we do that at our own, for our own convenience, but at our own peril. We agreed, all of us, to the pixel and the cookie when we signed up for the Facebook account and when we agreed to the upgraded privacy things. We just didn't realize exactly what we were agreeing to because we didn't really read it.
Yeah, and no one does, and I don't think it's possible to read all these things. I think it's actually not. I think it's all fiction. But like we pretend, like we click the accept, but that doesn't mean anything. And I hate those cookie things. I mean, I think they're just get out of my way. But whether I click accept or not does not mean clicking accept is get the hell away. Not I really want these cookies. I just don't want to be bothered.
Right.
So when we look at like what the courts are doing, so here we're in this situation. Plaintiffs have turned to this. They've started using SIPA and other state wiretapping laws. How would you describe how things are faring in the courts? Are the courts receptive to this? I see kind of mixed signals from the courts. Sometimes yes, sometimes no. Give us a sense of like how the courts are reacting to the plaintiff's theories.
So I'll say in the healthcare context, I've been tracking the motion to dismiss space very closely. I think only about 20% of motions dismissed are being granted. So 80% are being denied, at least in part, and mostly getting through. Of the 20%, most of those are without prejudice. So plaintiffs have an opportunity to amend. So at that motion to dismiss stage, predominantly these are getting through. Very few are getting knocked out that early. But right, that is just saying that this could sort of facially make a claim. We don't yet have a ruling. Sort of the key states that have that two-party consent requirement are, you see a lot under California and then under Pennsylvania. We don't yet have rulings from their Supreme Courts as to whether the wiretapping statute actually applies to use of pixels. But we do now have Massachusetts, and Massachusetts Supreme Court has said that it does not, at least in the context that they had, right? So there were some hospital claims that came before it where the only claims pled were under the Massachusetts wiretapping statutes. And they said that the use of pixels by those hospitals did not violate the wiretapping statute. And it did so based on lenity. It said that the statute didn't explicitly apply to electronic communications. And it's not really what you would think of wiretapping. And because it's a criminal statute, then you can't read it. You have to read it in favor of the defendant and find that it does not apply to this context. So we saw that, I think a few years ago in Florida, we saw that little surge of session replay claims. And there the Florida court said that is not wiretapping under Florida. I think in part because all that session replay was doing was capturing clicks and mouse movements. And they said that's not a communication. You're not communicating. Communication requires you to actually be like I am talking to a person and conveying an idea to them. That's a communication. Mouse clicks are not. And also, I don't think there's an expectation of privacy because there's pop-ups that said, we're using session replay and here's everything we're doing. And so if you have that pop-up and you click to accept to go to the website to use it, you are fully on notice that that is what is then going on now. So I will say most stuff is still getting through, but we have these little pockets where it's being dismissed.
I would agree with that. And I think it's important to note, as Katherine just said, a lot of this litigation, it's all filed at once, massive number of cases. I mean, I think over 13, we were trying to track 1,300 SIPA actions filed in the last year, 1,300 class actions. Those are just the class actions. It doesn't include this very active letter practice, demand practice that a lot of our clients are getting. You know, we're going to sue you. Settle with us now. We're going to file a bunch of arbitrations. Settle with us now. There's a whole hidden California Privacy Act, you know, pre-litigation also going on at the same time. And with that kind of a surge, all the cases are in the same procedural posture in the courts. So they're all at the very incipient stages, which is a motion to dismiss usually on the defense side. And, you know, those motions, the court has to assume that everything in the complaint is true. So assuming all this is true, you still don't have a claim. And so without any backdrop of precedential appellate decisions, what you are seeing, Dan, is exactly what you're noting. You win some, you lose some. You lose more than you win on the motion to dismiss phase. And then you have to take things to summary judgment when you actually have to prove, you know, the allegations in the complaint. And that's where generally the tables can turn a little bit if you get to summary judgment, because then, you know, you have to prove up that there's actual wiretapping, that there's actual eavesdropping, that there's actually a biometric being collected or stored or transmitted. And, you know, oftentimes there is no there. It's what I say a lot, as Katherine was noting. And so those cases get settled out before they get to summary judgment, because litigation is expensive.
Yeah. And don't in most cases, I mean, isn't it's all about settlement? Because I don't remember ever seeing a trial for any privacy statutory litigation or any data breach case, really. And all the data breach litigation, maybe enlighten me. I would love to see if there's actually a jury trial for a data breach case.
BNSF or BIPA.
There was one, yeah, BIPA, the famous the BNSF case.
Very, very rare. It's shockingly rare, like the number of cases that go to trial, because I think that the strategy in litigation, it's all about, you know, the plaintiff's lawyers will come in and they want a quick settlement. The real issue, okay, if you can make it through a motion to dismiss, that's going to mean a better settlement or increase the chance. But I wonder if we have, you know, some stats on this in terms of what happens in most cases. So we have, let's say, you know, 20%. You know, we have the pre-litigation cases, which may settle before we even start. Then there are the ones that start, they go to motion to dismiss, and you said 20% get knocked out there. So those might be just dead. But even those sometimes settle, right? Even after that, because they can refile. And then you have the ones that make it through that are going to be settled before summary judgment. And then, so I'm curious, like how does this look from the standpoint of settlement? Like, how do these cases ultimately get resolved? Because we're not seeing many actually go all the way.
So from my perspective, it ends up being determined by the maturity of, or kind of the law, the development of the law. So BIPA, we've talked about, there have been some key Supreme Court, Illinois Supreme Court and Seventh Circuit appellate court decisions in the BIPA space, right? So there are some things that are left to be litigated in 2025, and we can talk about that later on today. But, you know, you're getting to the point where if the settlement pricing isn't reasonable, you're going to take it to summary judgment. And so we're seeing more summary judgment motions getting granted in favor of defendants, you know, but those are the fewest cases, and the ones that are surviving are the ones that are, from the defense point of view, the strongest, where the pricing is just not right for it to settle. Either the case is too big and the price is too high, or the issue is essential to how the company operates its business. And so if it goes to the core of the business, you're probably going to stand and fight.
Yeah, because I'm just, you know, I think from the plaintiff standpoint, you know, they're probably, I think, mainly, I don't think they're even planning to go to trial in most of these cases. They, you know, just kind of looking for, litigate to the point where we can get a settlement, and then these cases get resolved in settlement. I think for data breach, even in the days when the courts were a lot less plaintiff friendly, you had a settlement rate that was like around 50%, even though the success rate of the cases was like 10% or very, very low. So I would presume that there's probably just a lot that are just going to say, look, it's just better to settle than to really press this. And so we will just see this keep developing. And then we see a law develop, but it's just going to be developing only at the motion to dismiss stage. Maybe a little bit at the summary, but you're not going to get a lot of legal development if you're just getting settlements. But that's kind of how this law progresses.
What happens, and it's based on the willingness of the appellate courts to give interlocutory appeals. Most of the case law in BIPA was made on denied motions to dismiss, which were appealed. It's unusual when you would think about that. That's pretty early in the litigation. Why? Because they involved issues that were capable of being repeated, right? That wouldn't get addressed by a court, that were about core ways to interpret the law. And the Massachusetts case we talked about, I call it VITA, VITA, for those of you that want to look it up and pronounce it correctly. That was really the first time that a court said, wait a minute, wiretapping, it has some criminal misdemeanor, provisions in it. It's a penal code. And for any criminal code, the basic rule, and Dan, you know this better than us as a law professor, is it has to be interpreted in favor of the defendant. Why? Because they could be criminally prosecuted for violating that law. So if there's gray, you should not be interpreting it against the defendant. And, that was an aha moment for me. And believe me, that's made appearances in briefs we're filing in SIPA cases out in California, because there's been no analysis as to just how broad can wiretapping be.
Yeah, I would say that, I used to teach criminal law, and, one thing about, criminal law is, it's very, very different for a company than it is for applied to individuals, because the rule of lenity generally, and varies from jurisdiction, but generally it actually is only when the law could be subject to kind of equally, valid interpretations, like very equal. Because if one interpretation's even slightly better than the other, a court can just say, we're just going to go with that interpretation, and there would never be an occasion for the rule of lenity to kick in. And it seems like we're getting a very generous application of the rule of lenity in these cases, because if we want to look at, areas where the law could be subject to multiple interpretations and could be somewhat ambiguous. Well, welcome to the law. That's every law. Every law is somewhat ambiguous, and everything would be the rule of lenity. If we truly were to kind of push the theory to its logical conclusion. And I think that's part of the problem is, legislatures are not very good at writing laws. And most laws are, if I had to grade most laws, they get D's and F's because it's just not well written. And, it's sort of a perennial problem in criminal law. And what's odd is that, we know in criminal law that there are these common problems that keep coming up in laws, and they've come up in laws for more than a century in the statutes. And yet, legislators and there's very easy ways to clear up some of these kind of common ambiguities in laws, but they don't do it. Sorry
to interrupt you, but what was interesting about VITA, and you hit it on the head, it did find ambiguity, because the term that courts are using in the wiretapping statute to say it applies to all these kinds of pixels is the term other communications. And so there's also the interpreting a statute with the likes. The things before it are not like what courts are dumping other communications into. And that's particularly, and that is how lenity was applied in the VITA case, right? Because the court said that is an ambiguous term. And that is the same term that's being used, the exact same term, other communications, in California to find all this pixel and chat and trap and trace. All those claims are being grouped under that. So I agree with you, there needs to be some clarity with the statute, but it also needs to be fairly, as I've said before we had this presentation, it needs to be communicated then what exactly, as Katherine was saying, is going to subject you to governance of those statutes. What business practices are going to subject you to these statutes that have normally been used in very different contexts, in a criminal context.
Yeah, I think that's one of the flaws with wiretapping laws. It kind of doubles as both criminal and civil. And I think that a former colleague of mine, Orrin Kerr, argued that it might be a lot better to sever and separate the criminal from the civil, because what makes for good criminal precedent doesn't necessarily make for good civil precedent, and vice versa. So it kind of it kind of creates a bad case law if we're doing criminal and civil at the same time, with the same language, with the same law. So that might be one way to improve things, but we'll see if that ever happens. It's also a good segue when you mentioned that phrase, other communications, that is the basis for the hook for a lot of these cases, because that it makes me think of the Video Privacy Protection Act, VIPA, which is another law that I'd love to talk about. This is a federal law from 1988. It's designed to regulate videos. Now, it was written in 1988. At that time, we're dealing with videotapes. And so it used the term videotapes. And it was really, at that point, everyone was just renting from Blockbuster. And so that was what they had in mind. But they wrote in the definition of the law something I actually like, because I think it's nice to have a law that is future-proofed, because technology changes so rapidly that if they only define videotapes to tapes, I mean, it would be obsolete. It would have been obsolete a long time ago. But they defined it to basically include, with a catch-all, similar, I believe was the word there, similar types of, video technologies. And that then has been used to apply, when DVDs came out, well, they got covered, and now streaming and online. So I'm wondering what is going on in the VIPA universe. How has that law been applied in ways that are, I guess, expected and maybe unexpected?
Well, certainly, and I think you mentioned this at the beginning of the call, the Salazar versus NBA decision out of the Second Circuit really revived a whole line of video privacy litigation that was filed around folks who weren't really how you or I would consider to be, or at least I would consider to be, consumers, of videotape materials. And that would be folks who get a newsletter and then get on a website later associated with that news, with the organization that issued that newsletter, and may watch a video on that website. And the question arises whether those entities are videotape service providers, and whether I'm actually a subscriber or a consumer covered by VIPA. And Salazar said, yes, I am, and very, very broadly interpreted that statute. There had been a mini surge of video privacy litigation in the Southern District of New York, and a lot of those cases had gotten dismissed on the grounds that just what I've described. And now all of those cases and more are getting revived. And what happens when you have that kind of a reversal is that then, again, you have folks rushing toward that circuit, which is viewed now as friendly and as willing to stretch the interpretation of the statutes, and then filing a bunch of new Video Privacy Protection Act claims. I just saw 2 got filed this week already in the Southern District of New York. It's very much looking like we're going to have a surge for some period of time because of that Second Circuit decision, both in the Southern District of New York or New York federal courts, but also we're seeing that surge repeat itself in around the country as people try to figure out where am I most going to get the most favorable initial outcome on my lawsuit. And that's a very broad interpretation, again, of what it means to be a subscriber of videotape or other similar materials.
Katherine, do you have any thoughts on the BIPA litigation? Anything to add?
Yeah, I'll say the only thing I can say about this, in addition, when these first started to come in, it was against the big media companies that you would expect. So people who are really putting out video content. Before the case law narrowed this and narrowed what it meant to be a subscriber and clarified that this really had to be only subscribers, we started seeing a surge of demand letters that were against, you could have like a hardware store that had, here's how to build a bench on their website, and there was a pixel attached to it. They would get these demand letters, and they would get mass arbitration demands and things like that. And so it really helped having the courts narrow this down to subscriber, and then and really limit this so they could grapple with just the companies that were profiting off their videos and actually charging content, like fees for that video content. I do worry that following Salazar, we're going to see an opening up, because it is so common to get free stuff in exchange for just providing minimal personal data. And so I'm cognizant that we will likely now see a new flood of these demand letters coming out again in the VIPA world against just about anybody that's got video content.
Do you think this is going to stay confined to the Second Circuit? Do you think it's going to start to spread? Or because I guess if the plaintiffs, I guess strategically you could say, look, if you try it in other circuits, you can expand it. On the other hand, then you risk creating circuit splits. So if you just keep going under the Second Circuit, you can stave off perhaps the circuit split that might trigger Supreme Court review on this. I don't know. But it certainly looks like we're seeing an increase in the Second Circuit on this.
But they're all over the country. Like, we do see these filed everywhere. There's a recent decision in Florida on VIPA with class certification that was interesting. So it denied class cert, but on numerosity. So the odd part to me about the decision is that it found that the class was ascertainable, even though there's no records of who specifically visited the website. So when you go and visit the website, the pixels aren't actually capturing like Katherine Heaton is the one that sat here and visited, right? It's at most maybe an IP address is captured, but often even that data is not stored by the video, whatever website has a video on it, right? That it might just be that the pixel just flared and sent off to Facebook that somebody watched that this IP, or it's usually this Facebook ID watched video, right? So it's not, they don't know, whoever owns the website, they don't know it was me. They don't know my address. They don't know how to contact me. So I don't think those classes are ascertainable, but the court said it was not going to grant or deny class cert on ascertainability. Instead, it did it on numerosity. And I was surprised by that argument. I'm curious to see if that gets picked up by other courts, because it's an interesting one.
And this goes back to what we were talking about every single user has the opportunity to set their cookies, right? And so do you have enough like people that don't have all these other filters on that would not have been impacted? The pixel wouldn't have fired or shared any information regardless, because of the number of users that would have prohibited that, turned that off.
Yeah, and that was the numerosity argument, right? It was, the court was saying there's so many percentage of people who are meta users, and of those percentage, this many percentage use browser types that don't support third-party advertising cookies. This many, could have cleared their cookies. And it was sort of that like analysis. The court whittled it down to, we have too small of a class for numerosity.
So what you're getting into is, people engaged in self-help, right? Because they're getting more and more requests to set their cookies and to clear their cookies. They're doing that. And then, they're also more reluctant to allow access. So they're shutting that down in more numbers than they used to. And so then there are more different efforts to try to reach out to market to that audience. How do you reach those people? And so, it's kind of this cycle that keeps perpetuating itself. But that was a very interesting decision, and, kind of points the way. Dan, what we're saying is you're a long way down the road when you're fighting a class cert motion, right? These are not issues that are going to get decided on motions to dismiss. And so the case law has to get more mature, or there has to be a defendant who, for various reasons, decides to stand and fight, because that's an expensive proposition.
Yeah, I guess one of the particular challenges that we face now is that kind of the online, video ecosystem, for lack of a better term to call it, is so complicated. And it's generally how things are so complicated online, because it's almost a village for every single site and technology, because, here we are, on LinkedIn, using a different platform, StreamYard, to do the video. And then this can be, go on YouTube, and it's going to be embedded into different sites. And then when you post a little video on social media, and then, so the thing is, like, we see like videos embedded into different sites, and snippets of things and technologies borrowed from many different providers. So it's like multiple players often. And then, anyone can kind of integrate video readily into their website, but they may have video put in there by one provider like YouTube or Vimeo, and then they might have, Google ads or some other kind of advertising thing separately that's on the same page. So it creates all sorts of complications, because we have all these different things kind of jammed together, working together. And how do we kind of sort that out with the law? Because it's it's obviously a very different context than before, where it's simple, right? You go to the video shop, you rent the video from the store, and the store has records, but that's it. Like, it's not like, 5 different companies and players and all these different entities, using the same thing and interacting simultaneously.
Agreed. And I think that's part of the complication. What's interesting about the Video Privacy Protection Act is there's also this idea that you have to knowingly disclose. And as Katherine gave that example, somebody puts up a video of how to make a bench, and their marketing team sells them on. Everyone's on TikTok, so they say, okay, I have to be on TikTok too. Very few people are probably watching that video, to be clear, but it was, sold as a package that people really did not fully understand how the pixel was operating in, and what it was disclosing, and whether it was actually disclosing the title of the video I watched, which is what's required, or just the page that I was on. Because most folks that were using those pixels were just trying to track, were they getting any traction with their audience on their website? They don't care that you watched how to build a chair. They're just trying to say, is anybody out there? Am I hitting a market that I want, of like self-help, or do-it-yourselfers is what I meant, or hobbyists and things like that. And so, we've learned. I mean, you learn from that litigation what not to do anymore. But it could be tough at the end of the day to claim knowing disclosure.
Mm-hmm. Yeah, well, it's complicated because, the consumers really have no idea, all the data and the 50,000 different ways that they're being tracked on a website. And they don't fully understand how all this works. But even the operators of a lot of sites that integrate these different technologies don't fully know what is going on. Like, do I know all the things that like Google's doing when I embed a YouTube video? No, I just embed the video, and so it's very easy to integrate all these different technologies in. But most probably don't really understand all the different things that the technologies they're using actually do. Mm-hmm. I think that's part of the, and it's hard to ever really know. But then who should be responsible? Like, who should be held responsible for what happens? The developer of the technology, the user of the technology. Who should be? Because I think there's some responsibility. If I use the technology and it's going to, do something that harms people, as a user, I'm not sure I should get a free pass. The creator, might not fully know all the different uses either, so they have only limited control. So,
But But I'll also say, like, to what harm? You're saying responsible, but for what, right? So if I'm a meta user, and especially I am a meta user, and I know exactly what it is doing because I'm involved in all this privacy legislation and stuff. Like I said, I proactively use this as part of my shopping experience.
Right.
I'm very cognizant too that if I don't want meta tracking me, I just use a different browser, right? But I know that I'm sophisticated. But as a meta user, it is totally in my control. I could also just clear my cookies. There's a million ways that I, the meta user, could just not be tracked by Meta, including I could just not be a meta user or use it, on a totally separate browser and then as compared to my online shopping. So I think you're right. There are things that should not be tracked. There is information that should not be shared. Would not want sensitive communications with my doctor to be shared, for example. So there's no business in having a pixel that's going to share that sort of stuff embedded in there. But predominantly, it is just not sensitive data that is being shared. And so is there really harm? And like, does this need to actually be remedied? I think that maybe people need to know, like, me as meta user should know what is happening when I'm using this product. But like, is that really the hospital's fault that I don't know? Like, should they be the ones, and should they just be educating me? Like, maybe class notice goes out that just says, if you don't want stuff going to Meta, clear your cookies. And here's a how-to on how to clear your cookies. I don't know.
I think the complication is, I know how to clear my cookies, but I want a lot of cookies. I don't want to just wipe them all out because then I have to log back into all these other sites. But then I have to go in and find the meta cookies and zap them each time. But sometimes I might want them and sometimes I might not. I don't want to use a different browser. It's not convenient to kind of go all over the place or log into another browser account. And also, a lot of consumers are just not going to think about it until it's too late. And the other challenge I think we face in today's age is, the fact that, like, what is sensitive data? And I've written about the difficulty of cabining sensitive data just to, like, what looks like health data, because we have the Target case going way back, where Target had an algorithm that could figure out if someone was pregnant based on fairly innocuous purchases, like just buying various everyday items. The algorithm could figure out sensitive health data, although none of the data that the algorithm used was in fact sensitive health data or anything that anyone would have been able to, at the initial instance, figured out would in fact give rise to an inference of health. And that's what these algorithms can do. They can make inferences that humans just cannot, through common sense, figure out. But the inferences could be pretty accurate. And so that makes it difficult, because how do I know, like, okay, what data could be used to infer the sensitive data that I don't want to be known? It all depends on then what the algorithm, might do to the data. But legislatures, the last thing they want to do, they're very afraid of, like, telling companies, okay, this is what your algorithm can do, and we're going to regulate the way you can analyze data, which is what I think they should do. But in the absence of that, if we only focus on just what looks like sensitive data, we're going to miss a lot of the inferences today that sophisticated AI can make, which gives us a big headache for regulation.
But then we get into harm, right? And maybe this is a transition. You may have Dan can pay me on the side for this transition. Look at BIPA. BIPA is a series of cases where the plaintiffs actually assert, I am not alleging any actual harm. I just want my statutory damages. I have not been harmed at all. No one has stolen my data, misused my data. It was used for the exact purpose that it was used for. And most of those purposes, it's destroyed just by the nature of the data, like finger scan timekeeping. Those are closed-end systems used by a known group of people, generally employees, and when they're gone, their data is wiped because it's wiped as an employee, not because of some sophisticated, retention or destruction plan. And those are the kinds of lawsuits where there's literally pled in the lawsuit, I haven't suffered any actual harm. You have to say, okay, maybe we should stop the madness. At what point? Because the data that folks claim is being used there is fingerprints. So it sounds super sensitive on its face. The same with, I would say, distracted driving technology. There's been a lot of lawsuits about how the AI underlying that works and what it does. And, those are safety you wonder whether there should be exclusions written into some of these statutes for things that are essential to keep us safe, because some tracking on websites is a good idea when you think about it, especially for retailers, for example, trying to track and make sure I am me when I'm using a credit card. That's why an IP address might be tracked, for example. And so, good intentions are getting lumped into bad intentions with allegations of no actual harm to recover statutory damages.
Yeah,
And
I think this is a symptom of, the fact that, we really lack many meaningful frameworks for the use of data. A lot is just focused on, the U.S. sort of a vestige of the notice and choice approach. Okay, to dump something in a privacy notice nobody reads, and then hold them to the notice. It's all a fiction. And then okay, now that you've had it and you've declared what you're going to do with it, you can kind of do it. But that's then the problem. The regulation doesn't want to go into the uses. It wants to just get it all out of the way with this silly fiction, and now we're seeing some of the problems with that. If we don't go down that road and really start looking at what's done with the data, then we're stuck with focusing just on the collection and these kind of gotchas, like, did you do these formal mechanisms of consent or not? And that's what the litigation is I think mostly about with BIPA. And with a lot of this is, did you, whatever. But that doesn't really get at okay, there's a lot of problems that does not cover that, we could be looking at. On the other hand, it's an easy gotcha. If someone didn't do it, doesn't mean it is a problem. I do want to, there's another law that, is being used in litigation. The Driver's Privacy Protection Act is something I don't know much about, and I'm curious what's going on with that.
Sure. There's been a somewhat of a mini surge in Driver Privacy Protection Act cases, and those are generally involve gateless entry or app parking, which many of us use today, very common. The Driver Privacy Protection Act is another 80s, maybe early 90s, but late 80s, early 90s law that was passed when a Hollywood actress was stalked using information from the Department of Motor Vehicles for the state of California that was obtained by a stalker who obviously didn't have a legitimate use for the information. That resulted in the passage of the Driver Privacy Protection Act, which is a federal statute, which was always intended to allow permitted commercial use. In fact, there are 14 permitted uses of DMV information, Department of Motor Vehicle information. And, what's being litigated here is whether when I park in a parking lot that has posted, contractual rules about if you park, you're going to pay, and I drive away without paying, can you use a photo of my license plate to look me up because I broke the parking contract, basically? And there have been numerous class actions pending in federal courts around the country on that front. And in full disclosure, I'm defending a few of those cases, so I'm somewhat familiar with them. But that's an area of the law, again, where a statute that was passed for one well-intended purpose that everyone would agree is a safety, has some safety implications, is now being used to sue folks who are trying to collect for parking. And I like to say, the only free parking is in monopoly. So, that's certainly a hot developing area of the law right now. And again, same thing, beginning of the surge, many motions to dismiss, not a lot of substantive decisions about whether the law should be applied to this technology that didn't exist when the law was passed. The iPhone didn't even exist. So the app didn't exist. All these things, when you trace them back to what existed at the time this law was passed and has it been updated, and does it need to be, are certainly key questions.
Yeah, I think that's a great point, and it really drives home something we said earlier, which is, we really see kind of a lack on the legislature's part to keep these laws up to date. And, that might work in other areas outside of technology, but with technology, that's a pretty bad not doing your job. And I think, if the legislatures did their job and really kind of kept the laws up to date, I think we'd see a lot less of these difficulties or these problems. But, we're in a world where we have these laws and they're 30, 40 years old. Some are even closing in on 50 years old. And the education privacy law, FERPA, is way out of date. It's a bad law these days. It desperately needs an update. The federal wiretapping law dates back to 1986. So that is closing in on 40 years old. It's before most people started using the internet. It's before modern email. It's before so many different things. So it's way out of date, and there's all sorts of ambiguities and questions and problems that are raised by this problem, this law. So these are really difficult issues that I think could be helped if legislatures were just working a little harder to keep these laws up to date. Because when I wrote a case book, it's 20 years old, and every 3 years I have to update it. I have to keep it going. And at the time, I was like, okay, I'm writing a book, and normally you write a book and you're done with it. But this book, I have to keep up with it. It's a commitment. It's like a child. You can't just have the child and then goodbye. And I think that's how the laws should be too in technology. So maybe be like a rule, like you have to update it every few years. But until we're in that world, we're going to be in the world that we're in, where we're going to see these old laws used with the newer technologies. I wish we had more time because I think there's a lot more details to explore here, but we're at the end of the hour, and I just want to thank you both for a really interesting conversation. I'd love to check back in to see how things develop, because we're seeing a lot happening in the courts and with the litigation, and very curious to see what ultimately happens with these DIPA and how the wiretapping litigation develops over time, because it's a pretty fast moving area that we're seeing now. And I think definite word on the street is like before it was, okay, you have to worry about data breach litigation, but I think companies need to really have privacy litigation on their radar, and they need to be thinking about dealing with it. So I would urge companies to talk to your privacy officer and pay your privacy officer more to look into this, because this is a big potential cost, and it can't be ignored for a lot of companies. I think a lot don't realize that they are, potentially could be sued for some of the things that they're doing. And they just don't know about this. So they need to pay more attention to privacy, because it's going to bite them harder if they don't.
Well, the pleasure is mine. It's not often that I get to speak with two people that are really leaders in their fields. Katherine, when Katherine asked me and you asked me to participate, I readily agreed, because you two are really the cream of the crop and well respected in your industries, and for your viewpoints. Much appreciated.
You are definitely the expert that we turn to very, very often for all.
Well, the feeling is mutual with both of you. I hope I get invited back.
Thank you both.
Thank you.
Thank you.
Bye.